Good afternoon. I am Josh Whitley, class of 2005, and a trustee of the college. Today's about really big deals. Of course, the American Constitution. Pretty big deal. And for the Constitution, we annually gather in honor of Dr. Linton R. Dunson, another really big deal in the life of this institution. Dr. Dunson was a former administrative assistant, which is now known as a chief of staff, to one of the most powerful members of the U.S. Senate. After that, he joined us at Wofford College for his academic life, where he spent more than 4 decades on this campus. He was chairman of the government department for a quarter of a century, president of our Phi Beta Kappa chapter. But first and foremost, Dr. Dunson was a teacher. His lectures were legendary. The men and women he taught revered him. His pedagogy was so enthralling that often you stopped taking notes to just listen. Although he taught principles of American government, state and local politics, and many more, Dr. Dunson's favorite course, I believe, was on the American Constitution. And he spent an entire class teaching the Constitutional Convention from May, when a quorum arrived in Philadelphia, until September 17, 1787, when the Constitution was adopted in the convention. For a semester, you felt like you were sitting in Independence Hall as Dr. Dunson lectured. You learned the clauses and the articles from the debates held inside the convention. From grade school to law school and many lectures since, I have never encountered a more powerful and brilliant lecturer than Dr. Linton Dunson. For that, along with several alums who hold him in the highest esteem, this annual Dr. Linton Dunson lecture on the American Constitution was established to honor him, more importantly to him, to honor the Constitution. Thank you, Johnny Linton, for your generosity of time and treasure for Dr. Dunson and always making sure we have the most esteemed lecturer and panelists for this occasion. Thank you to all our sponsors, our members of the bar, who honor Dr. Dunson and this institution. Thank you, Dr. Alvis, for your partnership. Thank you, Dr. Dunson's daughters, Katie and Meredith, for sharing your father with Wofford College. And I understand proudly and have met them. We have several grandchildren of Dr. Dunson who are here this afternoon. Now, students, Judge Childs is a really big deal. A really big deal. When the President of the United States needed a new Supreme Court justice, he only considered 2 persons, and she was one of them. She holds more degrees than any one person ought to. She is active in national organizations, the American Bar Association, president of the Federal Bar Association. She has served this state as a state circuit judge and served us on the United States District Court for South Carolina. Now she sits on the second highest court in the land, the United States Court of Appeals for the D.C. Circuit. It only has 11 judges. It was pretty remarkable for me last year, Judge, to listen to oral arguments in one of these current very, very important cases that will have a generational impact. And the panel of 3 judges, interestingly, all female. More interestingly, 2 of the 3, in a national court of 11 judges, 2 of the 3 were South Carolinians. And of course, Judge Childs was one of them. I first got to know Judge Childs when I was asked to serve on the Fourth Circuit Conference Planning Committee. I learned quickly, as will you, that she is a presence. She's brilliant. But I'm here to tell you she's also incredibly decent and kind and a heck of a lot of fun to laugh with and be with. I cannot stress to you students on this important day in honoring the American Constitution that we are in the presence of one of the most important judges to have ever lectured at this college. And that is our honor, Judge Childs. I'll close with this. Dr. Dunson, whom many credit with the transformational landscape in the National Arboretum that you see on our campus, once told me that he was touring his father, and he told his father after the tour and after talking about his courses, "Can you believe I get paid to do this?" That shown to his students every day for 43 years. For him and for the institution, Judge Childs Wofford is proud to welcome you for the Linton R. Dunson Constitution Day Lecture.
Good afternoon, everyone. And I want to thank Josh Whitley, Wofford Class of 2005, for a very warm introduction. Josh is a combination of being extremely smart and witty, and what a nice combination that is. And yes, he and I have shared lots of laughs, and I really appreciate that because this is a very isolating profession. So we need friends among us in our kind of insular setting in many ways. I also want to express thanks to Attorney Johnny Linton. I've had the opportunity to be here at Wofford College. This is a third time a charm because he's asked me a couple of times before to do some things and the dates did not work out, but this is a very special and significant occasion. So thank you. I'm glad it worked out for this particular event. He and I have worked together over the years. He ended up being a special master in one of my cases that lasted about 8 years. And I have a record for not letting that happen. So no fault of him, no fault of me, but they just extended the statute of limitations because it was a multi-district litigation case. And so he worked with us on the many plaintiffs in that particular case. So thank you for a great resolution of that particular case. Now, since its founding, Wofford College has been dedicated to fostering bright, young individuals in character, performance, leadership, service to others, and lifelong learning. And I'm also happy to be here with Representative Brenda Lee. As you all know, when you're on state court, you have to go through them. And so thank you so much for honoring me for my career at the beginning. And of course, I want to bring some thanks to my former judicial colleagues, still colleagues now, but I have Judge Guy Hill, who's now on the Supreme Court, served with us on circuit court, and of course Judge Mark Hayes as well, who was one of the go-to people, and then of course Don Coggins, who's right here. But one of the other things, you have to go through the state legislature, but you also have to attend the Christmas party of John White if you really want to be a judge. So thank you as well, John White, for being here. So this particular institution has been consistently recognized as providing a very fine liberal arts education and one of the best in the country. You've gone and made remarkable contributions to different fields because this is so important as we have a very global society. So President Samhat, faculty, distinguished alumni, and current Wofford students, I'm honored to be here to deliver this year's Linton R. Dunson Constitution Day address. I also want to express my gratitude to each of you, every one of you, being here to remember our enduring legacy of our nation's founding document. You're surrounded by awesome opportunities and incredible talents at this college. And as my address today is entitled Constitution and the Rule of Law, Linchpins of the Preservation of Democracy, I hope that you'll take away at least one sentiment. Just as the legacy of Wofford College relies on your commitment, the preservation of democracy depends on the dedication of all of us. Your commitment to commemorate this event in our nation's history is what truly enriches this occasion. So on September 17, 1787, the Founding Fathers signed the final draft of the Constitution in Philadelphia, marking the establishment of the nation's democratic principles, rights, and freedoms. Everyone knows the birth of the Constitution, but fewer know how the Constitution Day came to be. I want to begin my address acknowledging the efforts of a few of the citizens who helped establish Constitution Day. In 2004, Congress amended a 1954 law to designate September 17 as Constitution Day and Citizenship Day to commemorate the formation and signing of the Constitution and recognize all who, by coming of age or by naturalization, have become citizens. But traditions to celebrate the signing of the Constitution began long before they were formally recognized as a single civic holiday. In fact, early efforts could be dated back to the start of the 20th century and were observed on the grassroots level. Before Citizenship Day combined with Constitution Day, it was known as I Am an American Day. In 1939, newspaper publisher William Randolph Hearst proposed I Am an American Day to celebrate American citizenship, which Congress approved in 1940, setting the third Sunday in May for the observance. Because of the new holiday's popularity, Hearst subsequently produced a film titled I Am an American, which became a national hit. Our famous celebration took place in 1944. 1.5 million people crowded in Central Park to attend a naturalization ceremony for 150,000 people becoming American citizens. In his address for this special day, Judge Learned Hand described that within the hearts of every American lies the spirit of liberty. It is a spirit, he said, which is not too sure that it is right, which seeks to understand the mind of other men and women, and which weighs their interests alongside its own without bias. And in February of 1952, President Harry S. Truman signed a new law which changed I Am an American Day into Citizenship Day and moved its commemoration to September 17. In his proclamation regarding the new holiday, Truman linked the Constitution with the duty of an American. He said, "It is most fitting that every citizen of the United States, whether native-born or foreign-born, should on September 17 of each year give special thought and consideration to their rights and responsibilities under our Constitution." So the advent of Citizenship Day in 1952 gave inspiration to Louisville, Ohio resident Olga T. Weber. Weber, known in her community for handing out copies of the Constitution, the Bill of Rights, flag booklets, and patriotic leaflets, embarked on a journey that led to her successfully campaigning Congress to pass a resolution designating September 17th through 23rd as Constitution Week. The Senate and House approved her request, and it was signed into law by President Dwight D. Eisenhower. Then, decades later, in 1977, Louise Lee, a retired medical technologist from California, launched a movement to establish Constitution Day as its own national holiday. Her activism began when she realized how little many people know about the Constitution. Fueled by this awareness and sense of urgency, she never stopped trying to perpetuate the Constitution. Her aspirations would be realized in 2004 when Senator Robert Byrd, including a provision in an omnibus bill passed by Congress, mandating education institutions that receive federal funding to organize educational programs on Constitution Day. And on September 17 of the following year, Senator Byrd kicked off the Senate's first Constitution Day by sharing his personal devotion to the Constitution. He stressed that the Constitution depends on the personal commitment of each and every one of us to learn, to understand, and to preserve the governing principles that are set forth so clearly and powerfully in the text of our remarkable Constitution. Indeed, signing the Constitution by the 39 delegates was a pivotal moment in our nation's history. But just as crucial were the generations that followed, who continued its bedrock principles with unrelenting resolve. To grasp the Constitution's enduring impact, we must look to the judiciary, which has historically been entrusted with the power of ensuring that the principles of the Constitution are applied and upheld through the evolving landscape of our nation. So Article 3 of the Constitution establishes the judicial power, the Supreme Court, and its lower courts. Article 3, Section 2 states that the judicial power shall extend to all cases in law and equity arising under this Constitution. In 1788, Alexander Hamilton stressed that the Constitution must be regarded as a fundamental law, and the interpretation of the law is the proper and peculiar province of the courts. Over time, the role of the judiciary to say what the law is was reinforced with early 19th century rulings. In the landmark case Marbury versus Madison, Chief Justice Marshall cemented the judiciary's authority to interpret and apply the law independently within the constitutional framework. Later on, the passage of the 14th Amendment extended the judge's duty to protect liberty interests in the Constitution from state infringements. Some of the cases that are probably more familiar to you were the abolishment of racial segregation in Brown v. Board of Education, protecting free speech in New York Times versus Solomon, or ensuring marriage equality in Obergefell versus Hodges. The judiciary has been at the forefront of addressing some of the nation's most fundamental and significant constitutional issues. Now, given this constitutional foundations, judges have had to rise above their personal will and political expedience when adjudicating these cases. We have to apply the law independently, even if it means making the decisions that are not always so popular. One judge from South Carolina exemplified this resolve. Before the decision of Brown v. Board of Education, Judge Wadey's Waring of the South Carolina District Court, the court that Judge Coggin serves on now, presided over a pivotal voting rights case that challenged the South Carolina Democratic Party's prohibition on Black participation. Now, Judge Waring was the son of a Confederate soldier, so many anticipated his ruling given his upbringing naturally. But he stunned the public when he ruled that the Democratic Party was not a private club and therefore could not evade the 14th Amendment's protections against racial discrimination. He faced intense public backlash after that decision. Crosses were burned in his yard. Rocks were thrown through his windows. He was alienated by most of Charleston to the point that a local magazine described him as the lonesomest man in town. Despite this violence and vilification, Judge Waring never wavered in his commitment to protect American citizens' constitutional rights. A few years later, he went on to write the dissent of a decision that upheld school desegregation or school segregation, which was Briggs v. Elliott. That was the South Carolina companion case to the Brown v. Board of Education. It was the first case in the 20th century to challenge the constitutionality of racially segregated schools. He wrote that when the United States adopted the 13th, 14th, and 15th Amendments, It cannot be denied that the basic reason for all of these amendments to the Constitution was to wipe out completely the institution of slavery and to declare that all citizens in this country should be considered as free, equal, and entitled to all the provisions of citizenship. In his forceful dissent, he concluded that segregation was per se inequality. Now, this notion shook the foundation of separate but equal cases and paved the way for the Supreme Court's Brown unanimous decision in 1954. Another judge who played a crucial role in the civil rights movement was our own Judge Matthew J. Perry Jr., who was also on the District of South Carolina, and I had the fortunate opportunity that while I served there to then be in his office and in his courtroom and in using his red chair. He was one of my mentors. Judge Perry was the first Black federal judge to be appointed to the District of South Carolina in 1979. But he began his efforts to mandate Brown long before he became a judge. He advocated for the underserved and marginalized as a passionate civil rights lawyer. He started his law practice right here in Spartanburg and went on to litigate more than 6,000 cases. As a young lawyer, he overcame tremendous barriers. He would win hundreds of civil rights legal battles that resulted in the desegregation of schools, colleges, hospitals, parks, restaurants, and even a municipal golf course. His work resulted in the release of approximately 7,000 people arrested for protesting different forms of segregation. And one of his most notable cases was when he successfully litigated the integration of Clemson University, as well as the University of South Carolina and other public institutions in 1963. During his tenure as judge, he continued to implement the rule of Brown and held to his constitutional oath despite receiving personal threats by telephone and by mail for his decisions. Faced with this incivility, Judge Perry, endearingly referred to as the Thurgood Marshall of the South, called this just the spirit of the times. And when asked how did he deal with this affliction to his personal and professional reputation, he said he just dealt with it in his own terms, armed with the Constitution. So throughout history and to this day, the judiciary has been at the center of the nation's most vigorous debates and contentious constitutional issues. Amidst these challenges, we must never forget, as Justice Ketanji Brown Jackson said, that it's a matter of fundamental principle in our constitutional scheme that the rule of law is what governs. Now, we are at a time in American history marked by division and waning faith in our democracy. A recent poll conducted by the Pew Research Center found that only 19% of Americans think that democracy in the United States is a good example for other countries to follow. Yet we're supposed to be the boldest and the best country around the world. 72% felt that the United States used to be a good example, but not anymore. The erosion of confidence in our democracy, it's painful and it's very alarming. But it's also a poignant reminder to us judges. As the primary guarantors of stability, equity, and justice, we have to hold steadfast to protecting the rule of law. This duty is formally declared in the judge's oath, a proclamation that each federal judge must take before performing the duty of their office, and of course all other judges as well. So I've carried the meaning of the oath from my days as a state trial judge, a district judge in South Carolina, to my current role on the DC Circuit. Every time I pledged, I swore that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me under the Constitution and laws of the United States, so help me God. These few but weighty words remind me of the responsibility to uphold the judiciary's integrity entrusted to me. Since the day I took the judge's oath, my duty as a judge has been clear: to safeguard the individual's liberty interests by applying the law fairly and impartially to resolve the dispute. We follow precedents, as they are the cornerstone to carrying out our duties and upholding the rule of law. As the late Justice Ruth Bader Ginsburg said in her confirmation hearing, to be scrupulous in applying the law on the basis of the Constitution, legislation, and precedent is how we judges deal with controversial and tough issues. These pillars ensure fairness and reliability and stability within the legal system. They guarantee the evolution of legal landscapes that occur in discrete, thoughtful, and gradual ways rather than radical shifts based on personal beliefs or political currents. The judiciary's integrity lies within judges making independent, impartial, and fair decisions in each and every case before the court. But we also have to do so with humility and respect to all who come before us, because we preside over a wide variety and range of issues, and we have to administer that justice to the best of our abilities, hoping that our decisions will withstand the test of time. Now, as you heard, I serve on the DC Circuit, known as the second highest court in the land. It's an appellate court that has contributed many decisions impacting not only the DC Circuit area, but the entire nation. It was established in 1801 by the Second Judiciary Act of 1801. Since its founding, the court has experienced changes in its size, but we're now settled on 11 authorized judgeships today. And that composition makes us a circuit one of the smallest, but one of the greatest impact. Unlike most other circuits that decide cases across multiple U.S. jurisdictions, the D.C. Circuit has appellate jurisdiction only over the federal district court, the United States District Court for the District of Columbia. Also, unlike these other circuit courts, the D.C. Circuit has concurrent or exclusive jurisdiction involving review of federal agency actions. And those are the things that affect you most as citizens. In fact, an estimated 2/3 of the DC Circuit cases involve the federal government in some capacity, and approximately 1/3 of DC Circuit appeals are from agency decisions. So despite the court's small size, our national impact on our decisions is very great. For example, we hear cases of national import presiding over complex and sensitive issues, including national security, food safety, labor law, election law, clean air regulations. And I feel like this court is a lesson in history, because last week I was dealing with a case in the Republic of Angola. Last year I decided a case on Holocaust survivors. I have also decided cases on Guantanamo Bay, torture, terror, and other such issues. It has made decisions also protecting individual liberties, and it has examined the limits of executive power and also relied on significant election laws, including campaign finance reform and such other cases in that regard. And since the start of my tenure, one thing I've really been impressed by, that I really want the students to understand, is the immense collegiality of our court from everyone in the building. We all come from different backgrounds. We have different perspectives, But when we get off the bench, and in fact, when the cases are assigned to us, none of the judges speak to each other in terms of the cases. We go out there and we let the lawyers perform their oral advocacy. We ask questions of them, receive their answers, then we go back into a conference room. We then take turns speaking in a very cordial manner as to how we believe tentatively we will decide the case. If we don't agree with each other, there's no voice raising, there's nothing in that regard. We'll just say, you know, I see that differently. Or you might say, I've learned a new term, dubitant, which means let's see how you write it and then I'll see later if I'm going to agree with it. Or you might say, I might write a concurrence. I agree with you, but I want to come to it at a different way. Or you might even say, I think I'm going to write something on that, and so it's going to be a dissent. All in this same tone. And then there's the opportunity to go back and forth and, when the opinions are coming out with the various drafts in that regard. And so it's a very wonderful atmosphere, and I'm very glad to be there just from the intellectual stimulation, the enrichment among the colleagues, and all of that. But from these different backgrounds, we find a lot of common ground, and probably I don't know what the exact percentage is, but we generally get to unanimity in many of our cases, so we're proud about that. And this collaboration underscores the strength of the judiciary as we're able to engage in civil discourse and come to our decisions in a very collaborative and collegial manner, demonstrating that judges are united to our commitment and responsibility to upholding the Constitution and rule of law. And of course, the responsibility for protecting our constitutional principles and the rule of law doesn't just rest on us, it rests on you as well. This responsibility belongs to the attorneys who challenge the constitutionality of laws in court. It belongs to legislators proposing new pieces of legislation that align with the Constitution. It belongs to civic organizations advocating for civil liberties and civic education. It belongs to the students engaging in conversations on the importance of democratic values and learning about their civic responsibilities. It belongs to all citizens. We are all shaping the country's response to each major issue. By boldly beginning with "we, the people," the Constitution has always affirmed that its core is and always has been about the power and will of the people. President Franklin D. Roosevelt, in his Constitution Day address, emphasized that the Constitution is a layman's document, not a lawyer's contract. The late Justice O'Connor echoed this sentiment, reaffirming that the Constitution is not and can never be defined only by a group of judges. So in conclusion, in the end, there is no democracy without a collective commitment to uphold the Constitution and the rule of law. Each of us plays a role in safeguarding the fundamental principles that form the bedrock of our nation. For constitutional principles and the rule of law to protect us, we must protect them. As we confront persistent threats to the rule of law, whether big or obvious, whether small or insidious, it will be the strong culture of the judiciary and support of the judiciary and the support of our citizens that will see us through. Thank you for allowing me to celebrate Constitution Day with you.
Thank you very much, Judge Childs, for your wonderful talk today. We appreciate it. And it's my pleasure to introduce our panelists for the roundtable. But before I do that, and when I give them a chance to get seated, before I forget, I want to also remind you that following our panel, we have a reception in the Papadopoulos room, which is down in admissions. So if you just follow a pathway that goes right through here to the end of campus, You'll find the admissions building, and the Papadopoulos room is located there. So please join us for our reception following the roundtable. Joining us for our panel today, we have, first of all, Justice Gary Hill, Associate Justice of the Supreme Court of South Carolina. We also, too, have Judge Mark Hayes from the Circuit Court of South Carolina. We also have our own Simran Shana, who is first a Senior International Affairs major here at Wofford, and also, too, the Vice President of Campus Union. And then we were supposed to have with us today Judge Jacqueline Austin, a federal magistrate judge in Greenville, who actually occupies the seat formerly held by Judge Childs. She had to the chagrin of our audience, to our great disappointment, she had to attend hearings for an emergency preliminary injunction hearing today. To even greater disappointment of our audience, I'm going to take her place. So what we'd like to do is keep it a casual conversation. With our mics, by the way, don't forget to turn them on just by flipping them up. We want to keep it a casual conversation among our panelists and with Judge Childs. So we were hoping to ask Judge Childs some questions about either her talk, right, or also to her career in the law, and promote some conversation among our panelists. So in that vein, since I have the mic right now, I'd like to start. And if I could start with the following question, and that is, you talked about today in your Constitution Day talk, the importance of the Constitution as a bond of union among our citizens. And in fact, as you described, historically, the Constitution has been a way of defining the meaning of citizenship and the relationship of citizens to their government, both in terms of their rights and their duties. So I wanted to ask, the Supreme Court this year heard 60 cases. 70% were reversals of lower court decisions. And as you mentioned in your talk, we also live in a divisive age. And I wanted to ask you, in your impression, to what degree has that divisiveness affected the courts? And do you think that the courts will be able to transcend that divisiveness that characterizes our times?
Well, thank you again. What I would say generally is that we are the lower inferior courts. And so we have to deal with the facts, the evidence, and the law as we see it. And it comes before us in our various courts, whether it's on the papers, as you call it, the briefs, or whether it's through fact-finding through trial. And do our best to discern that and apply the law to the facts. We don't serve a role of judicial activism, trying to get to a particular outcome, but as an inferior court, we should be applying the law that is above us. We do have the opportunity, if we shall deem so, to criticize how the higher court has ruled on a case, but we're still bound by it. But that doesn't mean that we can't, in our opinions, perhaps address an issue that we think that they have not done so well in guiding us as lower courts with one of their decisions in that regard. And so I would just say that we just always have to maintain what we perceive as our fair and impartial role to keep the perception of the judiciary as a fair and impartial court for the citizens who are coming before us.
And along those lines, to what degree do you think sort of average citizens look to the court, right, to promote a notion of the rule of law and the Constitution that promotes unity, right? To what degree is the court an important guardian of that?
Very much so. I hope that when anyone comes before me, particularly at the appellate level where you have wonderful, sophisticated, very knowledgeable lawyers, that they don't believe I'm outcome oriented. that they know that they can come before me and do a fabulous job arguing their case, that I'm very well prepared myself and through my law clerks and staff, and I'm asking the questions that are necessary to help me get to a decision, but they don't feel that when they get there, they already know how I'm going to rule. And I think that that might be some of the perception of the Supreme Court.
Let's go right to left so you get together.
Thank you. Judge Childs, my question is kind of along the same lines. What are the potential risks to democracy when the rule of law is undermined, and how can citizens and institutions counteract those risks?
To the extent that you feel at risk, as I indicated, we all play our roles, and citizens, and talk about we the people, meaning the will of the people. You have to get to the voting booths. There are so many things that affect you individually from all levels, whether it's school board race, city council race, your various races where some states we're not, but they elect the judges. So you have to indicate your interests, and your interests are pulling that lever with respect to the vote, because that's also indicating what you're risking if you don't participate in the democracy.
First of all, thank you all for having me here, Dr. Alvis, and it's great to be with you on such a special day, and with Judge Childs and Judge Hayes and Judge Coggins and others, colleagues in the legal profession. And also I want to echo something that Josh Whitley said about the real reason we're here today, which is Dr. Dunson, who I was going to say taught me, but tried to teach me. And his lectures, as Josh pointed out, were really models of concision and erudition. And I see Katie back there, and I rely on things I learned from him every day about the structure of the Constitution. So it's a real honor to be here in his memory as well. I'll say a couple things about the rule of law and the judiciary's role in that. I think it is true that everyone looks to the courts over our history as protectors of individual rights and liberties. It's a counter-majoritarian document. Am I saying that right? I'm very cognizant of that and the responsibility that entails. I also would say that there is a lot of discussion around the country these days. It started back in the 70s and it's kind of reached some crescendo now about the importance of state constitutional law. Because of course we have two constitutions, the United States Constitution and the South Carolina Constitution. And one of the drawbacks to the U.S. Supreme Court deciding these issues that affect the entire nation of 350 million people is they can't issue rulings that please everybody or cover every situation. And in our federalism form of government, the state constitutions have become increasingly important. And you'll see a lot of articles about that in the media. There's a judge on the Sixth Circuit named Jeff Sutton who's written several books about it, about the importance of state constitutional law. And a lot of the rights that Judge Childs mentioned so eloquently in her speech that were later championed by the U.S. Supreme Court were championed first by the state courts because they were considered laboratories of democracy. So it's important to remember that the state courts have a role. It was somewhat diluted, justifiably so, during the civil rights era when the U.S. Supreme Court came in where the state's courts wouldn't go. But I would just say that as in terms of the rule of law, you have to remember there are two constitutions within
Thank you for having me as well, and Judge Childs, thank you for those wonderful remarks. I would love to get your comment on a topic touched on in your presentation that I frequently like to advocate when I'm being asked to address events. And here at Wofford, we hopefully have many people in the audience who are looking at probably entering the legal profession maybe, and probably some people in the audience who are just starting the legal profession. And it's an idea that is found in every ethical rules that apply across all 50 states, and that is the concept of a lawyer being a public citizen. And in the South Carolina preamble, as part of the rules of ethics that lawyers have to apply, there is a provision in there that aggressively talk about the role of a lawyer being a public citizen, and how it is that the lawyer's duty and responsibility in a successful constitutional democracy depends on the lawyer fulfilling that duty as a public citizen to enhance the confidence of the general public in what the judiciary does and also in the rule of law. And in your one of the presentations, you mentioned a hero of mine, Matthew Perry, and how that he embraced, in my belief, that he embraced this idea before he became a judge of the lawyer being that public citizen. And I wonder if you could share your comments to anybody in the audience who is looking at engaging in the legal profession as a career, to not only see the legal profession as being a job that you go to, but also you have this higher responsibility as a lawyer to being a public citizen. I wonder if you have any comments from about that.
I would say that you should approach this particular profession as a privilege. It's a calling because you are trying to articulate rights, responsibilities, and relief on behalf of your clients. And that requires you to fulfill the highest ethical and professional responsibilities in your personal life as people are looking upon you, and then also to have that credibility with the court. As we see you providing us the law, that we want to make sure that you're giving us what is true and that we can rely upon you so you have, dual responsibilities. And then I would take it to a higher level. Judges cannot speak out on their behalf. Whenever we have a case and someone is criticizing us, and that's fair, we can't do so. So lawyers, when you believe that whatever is being stated, you can be a champion of justice. That's law students as well. And what I mean by that is not picking a side, but just discussing civics education, discussing procedure, discussing the process. Perhaps there are things that are out there that make the public ignorant of certain things. And you can be our champions of justice to uphold the profession, to make us have a better perception with respect to that fair impartiality and fairness.
I appreciate you saying that. That's a very important thing. I wanted to ask one question real quickly. This is putting me on the spot. But one of the cases that was among the ones that Dr. Alex mentioned about being averse was Chevron. And I know you're right there on the hot seat with all the agency cases. Can you talk a little bit about the impact that's had?
Well, right now we're learning about it, but for those who don't know, Chevron was essentially a decision that you allow agencies who have the expertise for us as judges to rely on that expertise. For example, in dealing with any of these federal regulations, we may be dealing with Clean Water Act or some type of federal environmental regulatory control, gas emissions, things of that nature. So instead of having judges figure this out where people actually have professions as engineers, consultants, et cetera, as long as the agency is speaking within its own expertise, then the judge can look at that and see if it's reasonable to rely on that information. Well, with the new Supreme Court ruling in Loper Bright, they're basically taking that ability away from the agencies. It's a consideration, but not the only one, so it brings it back to us as the judges. I have not had we just started our term in September to May. I have not had a case that puts that right in front of me, But I do understand that the filings, which were 1/3 agency appeals, have increased over the summer, so I expected I would be having more, and we'll have to wrestle with, am I going to be the one who looks at all the expert reports and determines, what's valid? And it was never carte blanche, just take the agency's words. We have vacated or reversed several decisions if we didn't feel like the agency had done all of its processes, but now it's just putting a lot more emphasis on the judge in deciding those cases.
Yeah, I had a different question, but now I'd like to ask a follow-up on the consequences of the local right decision and the overruling Chevron. So I'll put both questions out there and you can ignore the first one, because I want to say I'm not asking for a preliminary judgment here. I've taught with judges for long enough now to do that. But I would like to ask a question about the broad impact, right, of Chevron, because that is an earth-shattering decision. Right? That is that there's no longer going to be this absolute deference, right, to administrative decisions when it comes specifically to any ambiguities in the law, which is an interesting situation given the fact that all laws have ambiguities. So I was wondering what your impression of that is. The other thing too I wanted to ask, so that you can ignore that question if you'd like to, is...
I would just say that the critique is that are we going to be policymakers, or will the Congress step in and add something to the rules, in terms of legislation, undoing that in some regard?
Well, also, I wanted to ask, along the same lines, if you could give us a kind of illustration about how a judge thinks, right, about cases, right, as opposed to how someone who's just heard, facts of the case would react without that judicial training. And so I was going to ask you if you could tell us a little bit about a couple of tough cases that you've dealt with, and what distinguishes the way that a judge thinks about that case from the way that an average person would look at the facts of the case.
And these are equally qualified persons. And I say that too because we've all served as circuit judges and trial judges, which means that unlike me now, that person is right in front of you. So I think the impact is greater in that regard. But we have briefs that come to us on either side. Of course, the case law is there. We have very qualified law clerks who prep us. They will write bench memos, kind of giving me an idea of what their recommendation would be to me. We speak about it a lot. I even have them do their oral advocacy by presenting to all the law clerks and making them, present the case as well, to give them those skills, but also it's just a way of listening to the arguments and thinking it through. And we really do a good push-pull. We have somebody serving on either side of the issue to see how we'll get to it. But of course, you're looking at the law. I can see at the appellate level, things are a little different for me because there's clarity in the law. There's the opportunity to see how far we want to go in the law with respect to the DC Circuit, and then also see what other gaps are there. Of course, looking at our own precedent, and sometimes we have to perhaps vacate a decision that we've had that would be rare, or clarify what's there, or just really just distinguish differences, because it's three people sitting on a panel writing for the entire court. And we have to keep that in mind too, that it's not my decision. I might write it, but I have to get two other people to agree with me. But ultimately, we send our decisions out to the entire court, and anybody could actually write and say, can you pull that? I want to look at it, or I have a little bit more I want to say about that or think about, or you've gone wrong because we have a case over here that did this. So I like that we have enough really bright talent thinking about any particular issue to get to that consensus.
Thank you. We touched a little bit on advice to students that are aspiring lawyers, aspiring judges. Specifically, how can aspiring law students gain valuable experience during their time in undergrad and make themselves stand out in a competitive field?
Lots of research and writing, particularly for our field. That's our craft and trade. So I suggest that you also should have the opportunity to either intern or extern. I work with all 7 DC schools and offer external opportunities where they work for a grade, and then also the University of South Carolina, since we persons who are particularly interested in appellate law, but sometimes trial work as well. And so that's the opportunity to be in chambers, thinking about these issues, and of course they know that everything's confidential until I sign it in ink, essentially, and send it off. Then they know that don't talk about any of the cases, because you could go along the way, see something, and you could change your mind. But that's the way to get into the chambers, think about how we think about things, and I make them all participate. Like they have that opportunity to be right there with us for those presentations, looking over briefs, maybe researching a narrow issue based on, the time commitment that they're allowed.
Well, back up just one to make a comment about what Judge Childs had said about the way that she processes cases. I am different from these two people sitting on either side of me, but yet these two people sitting on either side of me have sat in the same court that I sit in now, that I am a trial level judge. And so as a trial level judge, as Judge Childs mentioned, she gets clarity. It's sort of the trial judge's part of the responsibility is to try to shift through 100 issues that might be presented in the case and shift through the facts of those cases so that once it gets to Justice Hill's level, to Justice Child's level, maybe they don't have 100, maybe they just have 25. And so it's our responsibility at my level to actually make a record, to receive all of the arguments, to receive all of the evidence on these issues that are presented in front of me so that when it goes to Justice Hill or Justice Child, they have a more narrow, they have a more defined view of what the issues are in the case, both defined and narrow issue of law as well as defined issue of fact. Because I hear a lot of facts and a lot of evidence. I mean, Josh Whitley just was in front of me last week. I couldn't get him to shut up. But yet everything he said to me will be made part of a record, but yet we will take probably out of what we did as far as a judge and a lawyer, we may take 1 or 2 issues now that he then gets to take to Justice Hill or eventually maybe Judge Childs, and yet we then had a process, the judiciary process, of filtering through the facts and the law so that by the time it reaches their level, they have a more narrow, more defined view of it. But I just want to share that.
And where Judge Hayes is, or at least I thought, was the best job of all, because you had direct impact, as Judge Childs mentioned, and you had the opportunity to affect many people directly with your decisions on an appellate level, and that's where the battles are. And like they said, that's where things get narrowed down. Somebody said that appellate judges were kind of like the officers who come onto the battlefield after the battle's over and shoot the wounded, because there's not much left to do. All the important stuff has been done. But there are questions that come up that are narrow and have been crystallized. And then again, we have safety in numbers. There are 2 other people, and that is a great comfort because some of the legal questions are very difficult, but most of the questions, I would say, in the trial court and the appeals court, 90% of them are pretty straightforward. It's the other 10% that keep you up at night.
As a college professor, I have the greatest position of all, and that is that I can constantly issue summary judgments on cases without ever reading one question too, Judge House, about your experience on the DC Circuit. So the DC Circuit is just below the Supreme Court is one of the premier institutions of legal minds, and I was wondering, what was it like to show up on the first day, right? And you're surrounded, right, by people, right, who are, these extraordinary minds who have been serving on this court for a long time, and just to give us a sense of, what's it like to walk into that situation and then to find your bearings, right, and become a major contributor to an institution like that.
This goes again back to the collegiality with different ones reaching out to me immediately, sharing kind of their chambers manuals, how they do things. And I just went around to everyone's office over the course of probably 3 weeks or so, just brown bag lunch in their chambers and just chat with them, just about how they go about things, how they set just to kind of get a sense of the court. And I found that that was very helpful because it showed me that they believed that I was showing immediate sign of respect for their work, but that they were also engaging me, and they appreciate that I'm a trial judge, because some of them have come from academia or come from other agency work, and they actually look to me, for those decisions. And in fact, the DC Circuit sits in the same building as the DC Trial Court, and I have the ability to try cases. And so that's something I'm going to think about doing, and in fact, I tried to do it last summer, but one case, the federal public defender got ill, and another case settled. So of course, it would mostly be in the summer months, unless it's like a quick 2-day trial or something like that. Because they got back up on the January 6 cases with like over 1,000 indictments, and so they needed help just getting a regular case to trial in that regard. But it's very wonderful, real high-level experience. And, just the elephant in the room, for example, when I had the Trump immunity case, as I walked toward the courthouse, it was surrounded by several, police officers, law enforcement. Then going even to my secured floor, lots of marshals there. You felt like you're almost in a parade where you're being thanked for your service, And then when we get to the hearing, packed courtroom, but I felt so wonderful. And again, none of us spoke to each other in terms of anything about the case before then. We had a lot of discussions procedurally just about how we're going to handle things. And we just asked our questions for the course of about an hour, kept it very professional, and then we went back and did as we do with any case, discussing it, kind of seeing where we are. And because it's a per curiam decision where we all agreed, we all selected a portion to write, and I won't say which part I wrote, but we got agreement. But we actually edited each other's portions and just kept tweaking and tweaking and tweaking because we knew it was an opinion for the ages.
Judge Childs, we'd like to thank you for joining us today for the Nexsen talk. We really appreciate you being here.
And I must say, for somebody who wasn't supposed to be part of the panel, you're having a lot of fun.
Yeah. I'd also like to thank our panelists, Judge Hayes, Justice Hill, and also to Senator Shana for their participation on the roundtable today. It's been a great opportunity. We're very proud to be able to invite you to our campus, Judge Childs, and look forward to watching your career. Thank you very much.